continue admitting people, but we're going to go ahead and get started. This is a 1 hour CLE. We are in the process of getting it approved by the MCLE board. Midway through, I'm going to ask you in the chat box to go ahead and add your ARDC number and your full legal name that matches with the ARDC number. That way we can make sure to register all of you to get 1 hour's general CLE credit. This is an extremely important topic in today's world and with everything that is going on. A lot of back and forth with executive orders and the use of executive orders by the current administration. And the goal today is to get a better understanding of what the process is behind executive orders and the use of them in today's world. We have two speakers that Judge Samuel Bitar is going to introduce. Just by way of introduction, Judge Bitar was on the 13th Circuit for a number of years. Judged since 1998, I believe.
Yes.
You were on the bench. And he recently retired and is continuing to remain involved and took on the initiative of preparing this CLE and coordinating with the speakers along with our corresponding secretary, Joe Holmesy, who was very involved in getting this CLE planned. So without further ado, I'm going to go ahead and turn it over to Judge Bitar.
All right, thank you, Tony. So good afternoon, everybody, and welcome to the CLE on executive orders presented by the Arab American Bar Association. The Arab American Bar Association is the largest, oldest, and most prestigious bar association in the country, catering to the needs of our attorney and law student members, though membership is open to anybody in the legal community. I'd like to extend a special welcome to the students and coaches for the Loyola Law School mock trial team who are attending. I'd like to thank Joe Holmesy and the law firm of the Arnett Law Group for allowing me the use of their conference room for this CLE. Since I retired, I no longer have an office. So thank you very much to the Arnett Law Group. So this CLE will detail the definition, origin, history, and legal authority for executive orders in the United States. Some of the more consequential executive orders of the past and present will be examined. The impact and interplay of executive orders on the other two branches of government will be discussed. And finally, we'll discuss different perspectives on the legality and enforceability of current executive orders. This is obviously a timely and very fluid topic. And it seems that daily, if not hourly, we're inundated with reports in the news about executive orders being issued by the current administration. But I think it's important to examine the flurry of current executive orders in the historic context. In other words, executive orders issued by our presidents is nothing new. It's fairly commonplace. In fact, with one exception, from President George Washington through President Donald Trump, every president has issued executive orders. The one exception is President Garfield, whose term of office was only 6 months. He was assassinated while in office, and at that time simply didn't have the time to issue any executive orders. In fact, if you total the number of executive orders issued by all of our presidents, except Garfield, a total of 15,540 executive orders have been issued by our presidents. The most prolific author of executive orders was Franklin D. Roosevelt, who issued 3,721 executive orders during his 12 years in office. Some of the more significant executive orders of the past include George Washington's declaration of U.S. neutrality in the French Revolutionary War, Thomas Jefferson's Louisiana Purchase, Theodore Roosevelt's designation of public lands for national parks, of course, Abraham Lincoln's Emancipation Proclamation and suspension of habeas corpus, Franklin Roosevelt's infamous executive order providing for the internment of U.S. citizens of Japanese ancestry during World War II, Harry Truman's desegregation of the military, Gerald Ford's prohibition of political assassinations, which unfortunately for Vietnamese President Ngo Diem came over a decade too late, as he was assassinated in 1963, some believe upon direct involvement of the Kennedy administration. And then, of course, we have the more recent executive orders issued by President Donald Trump, and maybe one of the most significant ones, at least of his last administration, was the so-called Muslim travel ban. So I'd like to introduce our two distinguished speakers for today. We have Professor David Franklin from the DePaul University School of Law. He's been a professor there from 2004 to the present. Professor Franklin teaches administration law, conflicts, constitutional law, First Amendment, and torts. He's of counsel to the Chicago law firm of Massey and Gray. He formerly served as the Illinois Solicitor General, where he argued two cases before the United States Supreme Court. He's a graduate of the University of Chicago Law School and is a former law clerk to the Justice Ruth Bader Ginsburg of the U.S. Supreme Court. Professor Franklin's publications have been carried in the Yale Law Journal, the Iowa Law Review, Chicago Kent Law Review, and the Cardozo Law Review. We also are honored to have with us today attorney Kevin Fee, who's the current legal director of the ACLU of Illinois. Mr. Fee has worked for the ACLU from 2022 to the present. He's a former partner at the prestigious law firm of Sidley and Austin in Chicago, where he worked from 2002 to 2022. He has extensive litigation experience in federal and state courts, and he's the former lead trial counsel of the Illinois Judicial Inquiry Board. I'll digress. This will probably be the only time as a lawyer you'll ever see a judge willingly share the stage with a prosecutor from the Judicial Inquiry Board. So it's good to see you, Mr. Fee. He's also the former director of the Chicago Council of Lawyers. He's a graduate of the Harvard Law School, where he graduated cum laude. So thank you, Professor Franklin and Mr. Fee, for joining us. And Professor Franklin, I'll turn the stage over to you, sir.
Thank you very much, Judge, for that kind introduction, and thanks to the Arab American Bar Association and to Joe Homsey for inviting me today. I'm delighted to be here. Obviously, this is an extremely timely and important topic for us to delve into today, and I'm looking forward to our discussion. So let me set the stage by asking a very simple question. What is an executive order? So the judge already spoke about this to some degree, but an executive order is pretty much what it sounds like. It's a directive issued by the president, emanating from the White House. Executive orders are literally numbered, starting with Executive Order number 1, which was issued by Abraham Lincoln in 1862. So there were executive orders before Lincoln, but they didn't happen to be numbered. The Emancipation Proclamation was EO number 95, and we're now well into the tens of thousands. And that doesn't count, by the way, other kinds of presidential directives in the form of White House memoranda, et cetera, which would get us well into the many tens of thousands. I think the important thing to say right up front about executive orders is that, and this is really important, an executive order is not a law. At least generally speaking, we can say that an executive order is not law. There might be some exceptions to this general rule. Those exceptions would occur under situations where Congress has authorized the president to issue orders that bind private parties with the force of law. A good example here actually would be tariffs. Congress has passed various statutes over many years, for better or worse, delegating to the president the power to set tariffs upon the finding of certain facts. So those tariffs are, in effect, legally binding. But for the most part, executive orders are not legally binding on anybody outside of the executive branch. An executive order is a directive from the president to other actors within the executive branch. So say you work in an executive branch agency or a cabinet department or something, you're somewhere in the Department of Commerce and you get an executive order on your desk. This is like getting a memo from your boss, telling you how he'd like you to do your work. Obviously, you have to take such an order very seriously, but the law that governs you and your agency, and most importantly, the law that governs private parties in the real world outside of your agency, that law comes from Congress. It does not come from the president. So what you're going to have to do when this thing hits your desk is figure out how you can best comply with this executive order while at the same time remaining in compliance with the statutes that govern the activities of your office. The next thing to say, and it really follows from what I've just said, is that executive orders cannot themselves violate statutes or the Constitution, nor can executive orders order executive branch officials to violate statutes or the Constitution. That's the lesson that I'm sure all of you learned in law school when you studied the famous Youngstown case, also known as the Steel Seizure case from 1952. This was the case, of course, in which President Truman issued an executive order purporting to order the Secretary of Commerce to place all of the country's steel factories under federal control. And the Supreme Court held that he couldn't do that. And the reason that he couldn't do that was because there was nothing in the Constitution or any statute that authorized the president to do that. And in fact, what he was trying to do was inconsistent with congressional legislation. Now, there was one small asterisk in the analysis in the Youngstown case. And it comes across most clearly in Justice Robert Jackson's famous concurrence in that case, which again, I'm sure all of you read in law school. What Jackson said, and it's been influential ever since, is that the only time that the president is allowed to issue an order that violates a statute is if the statute itself is unconstitutional, perhaps because the statute unduly restricts the president's own constitutional authority. So this is a rather small exception to the general rule that says that executive orders can't violate a statute. Unfortunately, though, the Supreme Court has recently made that small asterisk much bigger in its decision last spring in Trump versus United States, which of course was the case about whether former presidents have criminal law immunity. And the court in that case indicated that, really for the first time, frankly, that there are significant limits on Congress's ability to regulate the president's conduct, the way he interacts with the rest of the executive branch, and so forth. So it remains to be seen exactly what the implications of the immunity decision will be, but that decision at least suggests that this circumstance in which the president is allowed to violate a statute, which in Youngstown was meant to be a very small category, could now be quite large. And that could, in my view, unfortunately, supercharge the president's executive authority. The other thing that might supercharge the executive authority of the president, and we don't have a lot of time to talk about it today, but I'll just mention it, is something called the unitary executive theory. So very briefly, what's the unitary executive theory? Well, it's the idea that everybody who exercises any part of the executive power is subordinate to the president. And on its broadest reading, the unitary executive theory would allow the president to essentially take any task that has been delegated to an executive branch official and order that official how to do that job, or even perhaps do it himself as president. There are still some kinks to be worked out with the unitary executive theory, but suffice it to say that our current Supreme Court reads this theory very broadly. And that might, in conjunction with the Trump immunity decision, sort of give the president more ability to ignore statutes when he issues executive orders than most people used to think he had. Still, as the Youngstown case exemplifies, executive orders are generally subject to judicial review. And so are the agency actions that are directed by the president in executive orders. And I think Kevin is going to talk in detail about how judicial review unfolds. For now, I just want to mention a couple of things that can complicate the process of seeking judicial review. And I'll be brief about this, but I want to at least mention these, and then we can perhaps talk about them later in Q&A. The first thing that complicates the process of judicial review is that the Supreme Court held a number of years ago that the president is not subject to the Federal Administrative Procedure Act, or APA. What this basically means is that all of the procedures that Congress has laid out for agencies to follow when they take action that affects private citizens do not apply to the president. The president is not subject to those limitations. And the other subject of the Administrative Procedure Act is judicial review. So ordinarily, agencies are subject to judicial review under the Administrative Procedure Act, but because the president doesn't count as an agency, his actions are not subject to APA review in court. And again, we can talk more about that later if you guys are interested in pursuing it. The second complication with respect to judicial review is that it can at least sometimes be challenging for plaintiffs to establish what is called Article 3 standing to challenge an executive order. Why is that? Well, because as I mentioned earlier, executive orders usually don't have binding legal effect on anyone outside of the executive branch. And so if you've got an executive order that hasn't yet been carried out by the relevant executive branch agency, your challenge to that order might be dismissed for lack of standing or for being unripe. Now, that hurdle can be overcome in various ways. For example, you can wait until the agency takes its action based on the executive order and then challenge that action. But at least it's something to be aware of as we think about judicial review of executive orders. So despite these two hurdles that I've mentioned, and there are some others, judicial review of executive orders is generally available, and it is often successful. Again, the Youngstown case was one example of a successful judicial challenge to an executive order. And sometimes these challenges result in injunctions. They can even be nationwide injunctions, which is a whole other topic of great controversy nowadays that we don't have time today, I don't think, to talk about. And again, Kevin is going to be your guide to some of the more specific details when it comes to judicial review. But what I want to do next is turn to some examples of executive orders that have been issued during the first, not even 3 months of the second Trump administration. And I've chosen 3 examples of executive orders to briefly discuss with you today. I could have chosen, dozens more, and that's because President Trump has been issuing executive orders at a frighteningly rapid clip. Not only has he done a lot of executive orders, but President Trump has issued orders that are extraordinarily broad, that have sweeping potential effects on private parties and private companies and universities and lots of others besides. And many of these executive orders, as I think I'm about to discuss with you, are frankly clearly unlawful. So this is a president who loves executive orders. He loves the pomp and circumstance of the signing ceremony. He likes to take out his big black Sharpie like he's some kind of king, making a law. But remember, an executive order isn't a law, right? It's just that Donald Trump doesn't understand that. Or rather, I think he doesn't care. This is a president who, in my view, it's been clearly established, does not care about the law, has never cared about the law, has never acted as though the law constrains him, has largely succeeded in conducting himself and his businesses over the years in a way that ignores the law. And this time, now the second presidency of President Trump, he is surrounded by others within his own executive branch who are encouraging him, right, to push his powers well past their legal limits, and by a Congress that is supposed to zealously guard its own institutional prerogatives, but has chosen not to do that. We have a Congress that is controlled by the same party as the president, that is, thus far anyway, completely inert and does not seem to have any appetite to stand up to the president, even when he issues executive orders that conflict with congressionally enacted laws, even when he, for example, pushes the global economy to the brink of recession with his capricious tariffs, although perhaps we will see some congressional pushback on that if the markets continue to slip. Okay, so I told you I would give you guys 3 examples of Trump executive orders. Let me start with what I think is perhaps the most egregiously unconstitutional one of all, and that's the executive order dealing with the issue of birthright citizenship. So this executive order, which you can see the title, the fancy sort of landing page on the White House website is on the slide there in front of you. This executive order purports to strip people who are born in this country of their citizenship if their parents were not lawful residents of this country at the time of the person's birth, or even if the mother was lawfully present but not permanently present, only had temporary status, as with temporary protected status or the like. And the reason this executive order is so obviously unconstitutional is because it flatly violates the very first sentence of the 14th Amendment, which says, as you can see on the slide, all persons born or naturalized in the United States and bend this executive order has focused on one phrase in this birthright citizenship clause, and that's the phrase subject to the jurisdiction thereof. So the administration's Hi, I think I may have lost my internet, but I hope I'm back.
Yeah, we can see you and we can hear you.
And can you still see the slide?
We cannot see that though.
All
I
right,
think I have to make you a co-host again.
let me pop that back on there. I've been having some strange internet troubles recently, so I do apologize for that. So I think what I was saying when I cut out was that this birthright citizenship executive order is being defended by the administration on the idea that children of people who don't have themselves lawful immigration status are somehow not subject to the jurisdiction of the United States. And that is just patently wrong. Subject to the jurisdiction means what it sounds like it means. It means subject to the laws of the United States. The phrase was inserted in the birthright citizenship clause in order to exclude a few narrow categories of people, like children of foreign diplomats or children of foreign occupying armies, or prior to 1924, Native Americans who were not subject to U.S. law. But children of undocumented immigrants are clearly subject to U.S. law, and therefore they are clearly subject to the jurisdiction of the United States. And that obvious plain language point is backed up by every other traditional source of legal meaning, whether you're looking at the common law at the time that the 14th Amendment was ratified, or you're looking at statements made by the 14th Amendment's framers, or whether you're looking at Supreme Court precedent, because there's a decision directly on point from 1898 called Wong Kim Ark, which makes clear that birthright citizenship extends to everyone born in this country, even if their parents did not have lawful immigration status. So this executive order has been challenged in federal courts across the country. And to date, I think there have been no fewer than 5 either preliminary injunctions or temporary restraining orders entered against it. And again, I don't think that's surprising, because the legal defense of this executive order is basically frivolous. And let me just say one more thing about this issue before we move on. Birthright citizenship is not just granted by the Constitution. It is a fundamental pillar of the 14th Amendment, which itself, right, is the fundamental pillar of this nation's attempt to establish a truly multiracial democracy after the Civil War. The birthright citizenship clause that you see on your screen is what overruled the Dred Scott decision. It's what allowed formerly enslaved people to be considered full members of the national community. And if the Supreme Court were somehow to allow the president to wipe away that guarantee with a stroke of his pen, which I don't think it will do, that would be to the court's everlasting disgrace. Okay, second example of a Trump administration executive order. Executive orders, he's issued several now that basically retaliate against private law firms. Here's one, just as an example, that he issued recently called Addressing Risks from Wilmer Hale. Wilmer Hale is a law firm. So apparently the president thinks that there are serious risks to national security or something coming from this law firm. Now, I may be biased here. I was a summer associate at Wilmer Hale 30 years ago. And the only risk I can remember is that there might not be any coffee left in the break room by lunchtime. But what does this executive order do? So it directs various agencies of the federal government to impose sanctions of various sorts against this law firm, including suspending the security clearances of law firm employees, terminating the firm's government contracts, and limiting law firm employees' access to federal buildings. The order, if you can go online and read it, right? It specifically calls out Wilmer Hale for having the temerity to hire Robert Mueller, who you will probably remember was the special counsel who investigated Trump's ties to Russia. So it's very clear, right? Donald Trump doesn't like Robert Mueller. He wasn't happy that there was a Russia investigation, and now he wants to punish Mueller's law firm. So this executive order is clearly, right, designed to retaliate against a private partnership for the cases and causes it has chosen to pursue and the people it has chosen to hire. Now, it is internet seems, or maybe it's on the Zoom end. Maybe Zoom continues to have problems with me. I hope it's not because of the content of what I'm saying. That would be troubling. Very quickly on the law firm executive orders, it's very clear that this one and the others are designed to retaliate against firms because of their speech, because of their petitioning against the government for redress of grievances because of the people they associate with in order to express a message. And it's just hard to think of a more blatant violation of the First Amendment than that. I'll just show you some language from a relevant Supreme Court decision. I could show you half a dozen others that make clear that this kind of executive order clearly exceeds the powers of the government as a whole. Even if Congress were to do this, it would be unconstitutional. But certainly when the president attempts to do so on his own, it's even more blatantly unconstitutional. So it's not surprising at all that Wilmer Hale, which is represented by the nation's most prominent conservative appellate lawyer, Paul Clement, has already won a temporary restraining order against this executive order. And you guys, I'm sure, are aware that there are some other prominent law firms that decided not to fight the Trump administration. Firms like Paul Weiss and Skadden Arps and others that have decided instead to enter into settlements to agree, for example, to donate lots of pro bono hours to the administration's favored issues. I think those decisions were very bad decisions. I think they're bad for the country. I think they're bad for the rule of law, but I also think they're bad business for the firms. You know, if you're a firm and your current and prospective clients see you knuckling under to the administration, why would they hire you to fight for them in the future, right? You know, entering into agreements with the government basically hamstrings these firms. It means that they are going to have conflicts of interest in every case or matter or transaction that involves the government going forward. And frankly, the administration and these firms are entering into agreements that I don't even think are written down anywhere. And to the extent they're written down, they're not worth the paper they're written on, because we know the Trump administration is going to insist on extracting more and more and more from these firms. So I think they are entering into a devil's bargain. And I'm really glad to see Wilmer Hale, a firm that I had some small association with many years ago, choosing a different route and fighting in court. Okay, I know I'm taking a lot of time, so here's my third and final example. This will be a little bit on the lighter side. So let me introduce you to an executive order issued by Donald Trump that deals with the nationally important issue of maintaining acceptable water pressure in shower heads. Okay, you know, many of you will be aware that this is an issue that Donald Trump cares a lot about. If you've ever listened to a Trump campaign rally, he went on and on about how he didn't think that water pressure in showers was strong enough. And so he's now gone ahead and issued an executive order on this topic. So what he's done here, not to spend too much time on this, but he's ordered the relevant agency, the Department of Energy, to rescind the existing definition of shower heads. I'm told that the way this works is that there's been some controversy over what constitutes a shower head. So for example, if you've got one of those showers that has multiple shower heads, you know, that sprays your whole body, like the horizontal ones that hit your tummy, which I find very disturbing, right? But anyway, you've got this shower that works that way, right? Is that one shower head or is it multiple shower heads, right? Democrats apparently like one shower head because it conserves more water, whereas Republicans like to be able to install multiple shower heads because it allows more total water flow, which seems to be what Trump likes. And so the executive order directs DOE to rescind the current definition and start all over again. But even with this more frivolous example, and I admit this is a rather frivolous example, there is actually a darker side. Let me show you just one passage from this executive order. Okay, so here's Trump. He's ordering the Department of Energy to rescind this definition. But in the highlighted sentence, he says something really interesting. He says, notice and comment is unnecessary because I am ordering the repeal. Now, to decode that bit of administrative law jargon for you, notice and comment, as many of you know, is the process by which the public gets to weigh in on the pros and cons of a proposed rule. And basically, if a rule was enacted through notice and comment, then the rule can only be rescinded through notice and comment. But here's the president armed with his notion of the unitary executive theory, basically saying, but if I tell the agency to get rid of a rule or a regulation or a definition of showerhead, I can just tell it to do so without getting any input from the public. And I think that is, in its own small and slightly frivolous way, yet another example of the president claiming constitutional authority that he doesn't have. So we're going to have to see what happens with all of these executive orders. Many of them have already been enjoined by the courts. But as you all, I'm sure, are aware, we're in a very rapidly evolving situation where the president is claiming the authority, or appears to be claiming the authority, to ignore or violate court orders, right? We've seen that in the litigation surrounding the Venezuelan immigrants who were shipped off to a Salvadoran prison, or Mr. Abrego Garcia, a Salvadoran resident who was shipped off to a Salvadoran prison. And the administration seems to take the position that the courts cannot order him to do otherwise. If that continues, if it continues in the face of an unambiguous Supreme Court order to the president, then we will be right smack in the middle of a constitutional crisis if we aren't already. But that is a topic, thankfully, for a different day. So with that, I will end and hand things over to Kevin. Thank you.
Thank you, Professor. Go ahead, Mr. Fee.
Thank you, Professor, and thank you to the Bar Association for having me here today. I'm just going to share my screen again. Are others able to see the slide on the screen? That's great. Okay.
Yep.
So again, thank you for having me, and thank you for that great setup from Professor Franklin. These are obviously timely issues that we're concerned about a lot here at the ACLU. Of course, have to give my standard disclaimer that I am speaking in my personal capacity and not on behalf of the ACLU today. But what I'm hoping to do for the remainder of the presentation, building on the great kind of foundational concepts that we just got from Professor Franklin, is to get in the weeds just a little bit more on the first kind of the history of executive order litigation, litigation challenging executive orders, both kind of directly and indirectly. And that's a distinction I think that's going to be important going forward. Then a bit more about the modern litigation approach to executive orders and how to challenge them in court. Which is, somewhat fluid in this modern era of, the use of executive orders that is itself rapidly evolving kind of before our eyes. And then I'm just going to give an overview of some pending executive order challenges. There are many that have been brought by many individuals and organizations. I will be focusing on a few that are brought by, of course, the organization that's near and dear to my heart, the ACLU, but this is, these are by no means the only challenges. There are dozens and dozens of active challenges to the dozens and dozens of executive orders that President Trump has signed since he took office. So first, a bit about, just at a high level, kind of the history of executive order litigation. And this is, again, building on sort of what Judge Bitar had mentioned at the beginning of the presentation. Executive orders are obviously not new. There have been hundreds and hundreds of executive orders, some of which have been quite significant, quite consequential. Judge Bitar gave an overview of a few of those. I don't want to give the impression that executive orders are somehow new. I do think that the litigation approach to executive orders has changed quite a bit in the modern era. This sort of notion of very broad, very consequential executive orders started to kind of take center stage, in the modern era, kind of under the Reagan administration, and then it's evolved through administrations since then. And of course, we've now seen this really unprecedented explosion of executive orders under first the Trump 1 administration in 2016, and then now, to a degree of magnitude larger, the explosion under Trump 2, where we've seen over 120 executive orders, many of really stunning and sweeping breadth in just the last few weeks. And I just put a quick citation to a really great law review article here in the University of Chicago Law Review by Lisa Mannheim and Catherine Watts. And I used many of the concepts of that article to form this presentation. So I wanted to give credit where credit is due. So there was a time that sort of direct executive order challenges were relatively infrequent. And the reason for that was that there is and has been a very robust body of law that's sprung up around the Administrative Procedures Act, which is the statute that allows for a very detailed and robust means of review of actual agency actions. It's a framework that applies to the actions that agencies take in the administrative state. As Professor Franklin mentioned, under the Franklin versus Massachusetts Supreme Court case in 1992, it became clear that the president himself is not considered an agency under the Administrative Procedures Act. And so the president's direct actions are not reviewable under the APA. As a result, the sort of standard playbook on challenging executive orders, even those that litigants had grave concerns about for a long time, was to wait for the agencies to actually take action under the executive orders and to then challenge those actions under the APA and under the framework that the APA provides. There was sort of little need for courts to directly examine executive orders, which brought all sorts of complications from a litigation perspective that Professor Franklin alluded to, problems with ripeness and standing. And so what you had when you talked about sort of executive order litigation throughout most of the modern era has been really APA review of actions downstream from executive orders. A president would issue an executive order that would sometimes be, or at least purport to have the force of law, but more often just sort of provided marching orders to the administrative state, to agency heads, to employees of the agencies to implement a sort of a broad policy, and then litigants would wait for those policies to take shape and challenge them, usually under the APA. So the APA, as I said, it's sort of a broad framework, but the most important aspects of it in terms of review of executive order sort of follow-on actions are arbitrariness, which is kind of sometimes called the hard look review, procedural review, and then I want to talk a little bit about Chevron deference and its recent demise, which was and remains sort of an interesting and foundational doctrine in the area of administrative law. So APA review of downstream agency actions that followed on from executive orders. First, arbitrariness hard look review. So this is based on section 706(2)(a) of the APA, which directs courts to hold unlawful and set aside agency action that's found to be arbitrary, capricious, and an abuse of discretion, or otherwise not in accordance with the law. This form of APA review of agency actions was initially quite deferential, but it kind of evolved to grow some more teeth over time, especially in the 60s and 70s, as judges became concerned that some of the agencies had the potential to become captured by private interests, or perhaps were already captured by private interests. It evolved into what is, a much more searching degree of scrutiny, the hard look review that kind of takes a hard look at agency actions, the evidence supporting them, their adherence to law, and this is the kind of one of the main APA reviews that you saw that gave some constraints to executive orders in the 70s, 80s, 90s, and even into the 2000s. The other part of APA review that was really important in challenging the again sort of downstream aspects of of executive orders was procedural review. So there's multiple kind of procedural requirements imposed by the APA, in particular, Section 553, which is the source of the notice and comment period, for example, that Professor Franklin just alluded to. It requires agencies to issue a notice of the proposed rulemaking, including a description of the subjects and issues involved, to accept written comments from interested persons, and issue a concise general statement explaining the final rule's basis and purpose, called the SOBP. So, this was another aspect that was kind of front and center in challenging executive orders over the past generation or so. And then a kind of an overlay and a doctrine that that was important in APA litigation up until very, very recently was this notion of Chevron deference. So this is of course, in reference to the famous Supreme Court case, Chevron versus National Resource Defense Council in 1984, that required courts to really defer to agencies' interpretation of statutes. So it's really empowered the administrative state, to take the actions necessary to give life to legislation and legislative mandates that came from Congress. And so it really limited judicial review of actions of the administrative state for quite some time, until it was recently overruled by the case Loper-Bright Enterprises in just this last year, its last term in 2024. So Loper-Bright really strengthens judicial review of agency action. It really allows courts to exercise their own independent judgment in deciding whether an agency has acted within its statutory authority. So it lets courts do what courts typically do when they interpret actions, using canons of statutory interpretation and the ordinary sort of tools of the judicial trade in scrutinizing agency actions going forward. Now, this was hailed as sort of a conservative victory at the time that Loper-Bright was issued. The obvious reason for that being that regulation and the actions of the administrative state are more often, rightly or wrongly, associated with sort of the political left than the right, and deregulation has long been a priority of the modern Republican Party. Not quite so clear how that cuts in 2025 when you have a Republican president who has essentially taken control of the entire administrative state, is attempting to rule more or less by fiat while dismantling the agencies that have taken shape over generations and the public servants that serve within them. Now you have this sort of interesting turnabout where, or at least potential for turnabout, where it may actually be more difficult for the current president to carry out his agenda through the executive branch because of the strengthened judicial review that he's going to face as a result of Loper-Bright. So, likely to create pretty robust review of agency actions under President Trump's EOs in a way that he would not have faced and did not face, for example, in his first administration. So these are the types of EO litigation that most folks talked about before the Trump era, right? This is like the Reagan EO that directed agencies to consider costs and benefits when engaged in rulemaking. That was not challenged directly. It was challenged when the agencies put it into place. Similarly, Obama's directive to the Department of Labor to modernize and streamline rules governing overtime pay, that was a sort of a standard indirect APA type challenge to the pronouncements contained within that executive order. So direct EO challenges, that is, challenges to the orders themselves, usually even before agencies have had an opportunity to carry out the pronouncements of the executive order through agency action. it was not unheard of for those to be challenged, of course, historically, but they were quite they were infrequent as compared to standard kind of indirect APA challenges. That was in large part because they were not really necessary. There was this large body of APA law that gave kind of a clear framework for legislating or litigating, excuse me, these executive order issues. But there have been some instances, Youngstown being a famous example, where there have been kind of direct challenges to EOs. But direct EO challenges are something that you started to see much more frequently, especially in the first Trump administration. And with the kind of explosion of very broad, very impactful, at least potentially impactful executive orders, you started to see a similar explosion of sort of direct litigation challenges, which predictably presented a number of challenges for litigants. I mean, the first being that most executive orders, and especially executive orders issued by this administration, are kind of a mix of purportedly legally binding aspects and then legal orders that are not binding, marching orders, essentially, instructions to agencies to take actions, authorization of investigations, recommending commissions, commissioning studies, recommending prosecutions, things like that, that do not have the immediate force of law. They don't impact legal obligations or have direct impact on private parties. And as a result, lead to, difficulties in establishing standing. So you might have an executive order that's a mishmash of, effectively purportedly legally binding pronouncements like the birthright citizenship pronouncement that Professor Franklin just mentioned, and then also a host of other non-binding directives, and then really sometimes what would amount to just sort of bluster and the equivalent of press statements, really phrases that are added to executive orders as kind of a bone to political constituencies, really just kind of political statements. So you sometimes have multiple purposes served within one executive order, and so the path to direct challenge is not always clear. You've got ripeness and standing issues, and you lack the clear framework provided by the APA. So as a result of that, the body of case law that applies to these sort of direct challenges to EOs is not all that well developed. I mean, it's the relatively few cases that have involved direct EO challenges have mostly sort of borrowed concepts from other contexts, administrative law, statutory interpretation, and there's not really a super developed and strong framework that judges can use to deal with these direct challenges, which of course now are more common than ever. So the current administration has further sort of complicated this important distinction between legally binding or purportedly legally binding executive orders and those that merely act as sort of policy pronouncements or marching orders by sort of publicly characterizing executive orders as fully binding and presidential authority is essentially unlimited. And then, simultaneously in court characterizing EOs as falling within the sort of non-binding, just bully pulpit category. And that's actually a phrase that's been used by Trump administration lawyers on more than one occasion. They sort of downplay the actual impact of these executive orders, saying, oh, this is just an instance of the president using his bully pulpit. Essentially, he's just kind of showing off. This does not have the force of law. Therefore, the plaintiffs who are challenging this executive order lack standing. So that's the framework under which parties that are attempting to challenge executive orders are now working. So that you have this choice of either immediately challenging an executive order, before it clearly goes into effect, to hopefully beat the administration to the punch and avoid what are oftentimes really devastating potential consequences of an executive order's pronouncements, while facing standing issues and this largely undeveloped body of law governing direct challenges. Or you can wait, sort of take the old-fashioned route and wait for the downstream agency actions, by which time it may, in some senses, be too late. I mean, for example, when you're talking about withdrawal of federal funding, I mean, if you actually wait for the funding to be withdrawn, that can be a situation where agencies, foundations, other entities that rely on federal funding have already effectively been devastated if you wait for the funding to be cut off. So, the theories for challenging executive orders directly are, most commonly it's for violation of a constitutional provision, First Amendment violation, due process violation. Also sort of what is developed as an equitable cause of action for exceeding statutory power, ultra vires, inconsistency with a federal statute, such as, the theory under the challenge to the first Muslim ban, which was that even though the INA, Immigration Nationalization Act, doesn't provide for a private right of action, the Muslim ban, as it came to be called, was effectively inconsistent with the dictates of that statute. And then you occasionally will see, the non-delegation doctrine, the idea that Congress overstepped bounds in delegating power to the executive branch without appropriate guidance. And the standard of review in these direct challenges is itself still evolving and kind of being developed. And you see some inconsistency in the treatment of and review of executive orders. Sometimes courts will use what's effectively a rational basis review that's highly deferential to the executive branch, that doesn't require, for example, evidence. It applies somewhat limited scrutiny. Whereas sometimes you'll see, courts applying a more exacting reasonableness standard that's more akin to the APA hard look. The Supreme Court has not sort of fully defined this standard of review, which provides another challenge for litigants seeking to directly challenge executive orders. So, as it stands right now, there have been over 120 executive orders issued in 2025. I think we're up to 124, if I'm not mistaken, as of this morning. I have a very large 3-ring binder that was recently overwhelmed as I tried to keep track of each of these as they come out. And I'm now on to a volume 2, which I expect will probably be filled before the end of May at this rate. So you've seen many challenges falling into kind of both of the categories that I've discussed, the more traditional APA challenges to agency actions and direct, mostly constitutional challenges. And so just a bit of an overview on both, on some of the ACLU challenges that have fallen into both of these categories. First, I will only touch on this briefly because Professor Franklin did a great job talking about the executive order ending birthright citizenship. This was, basically the first executive order that the administration issued. I think that was not by mistake. I think it was by design for the reasons Professor Franklin stated. I also think that it functions as a bit of a trial balloon because of its brazenness, frankly. I mean, the fact that it flies directly in the face of the text of a well-established, constitutional provision that has also been reaffirmed in statute and upheld by bedrock constitutional precedent. It's sort of an attempt to to push the envelope and see where the Supreme Court is going to be willing to go in tolerating this administration's lawless actions, in my view. So there were multiple cases directly challenging this executive order. This was an example of one that purported to have the force of law. It was challenged by several coalitions of state attorneys general. The ACLU brought its own challenge in the District of New Hampshire on behalf of a number of community organizations advocating for immigrants, relying on associational and organizational standing. Each of these cases has resulted in a TRO, or preliminary injunction. The claims in the ACLU case were, of course, 14th Amendment, because the plain text of the 14th Amendment confers birthright citizenship. 8 U.S.C. Section 1401A further codifies it. And the U.S. v. Wong Kim Ark, 1898, famous Supreme Court case, explicitly granted birthright citizenship for all people born in the United States, overruling Dred Scott's, racialized two-tier system of citizenship. So on February 10th of 2025, Judge LaPlante issued a preliminary injunction, joining judges in several other districts who had done the same in response to the state AG lawsuits. So that is an example of a direct challenge to an executive order that remains pending. It is up on appeal. Will eventually reach the Supreme Court, where we expect and hope that it will be upheld. Another example of a more or less direct challenge to an executive order is the PFLAG versus Trump, which deals with gender-affirming care. This relates to executive orders 14-168 and 14-187 that together direct federal agencies to ensure that institutions receiving federal grants and all gender-affirming medical care for youth and adults under the age of 19, regardless of circumstances, regardless of the wishes or recommendations of the patient's physicians. This was brought by a coalition of physician groups, LGBTQ plus advocacy groups, as well as impacted individuals receiving this care, and sought to enjoin the executive orders from halting medical care that was underway. The claims were ultra vires, in particular, inconsistency with federal anti-discrimination statutes, which prohibit discrimination on the basis of sex, among other protected categories, the Equal Protection Clause, substantive due process, and the First Amendment. The TRO was granted in the PFLAG case on February 13th of 2025, and the PI granted on March 4th, 2025. So this was another example where there was a direct challenge that was, upheld. The unconstitutionality of the EO was noted relatively quickly. Those cases remain pending. Another example, non-citizen removals based on speech. So there have been several cases in this category. This is kind of moving into more the downstream, more traditional, indirect challenges to executive orders. Executive orders 14-161 and 14-188. Through these executive orders, which related to purported efforts to address anti-Semitism and terrorism, through their own language and related policy statements by the State Department, the administration articulated a policy where they had promised to deport non-citizens who had been active Palestinian protesters or protesters of U.S. or other institutional approaches to the Israel-Palestine conflict. One such case, the case of Ozturk versus Hyde in the District of Massachusetts, involved a PhD student from Turkey at Tufts University who was detained on the streets of Somerville, Massachusetts by agents of Department of Homeland Security, detained in Massachusetts, and deportation proceedings were initiated. The apparent reason at the time was that she had written an op-ed piece in the Tufts University newspaper that was critical of the school's policy with respect to the Israel-Palestine conflict. That was since confirmed by State Department. Marco Rubio admitted that she was targeted as a direct result of her speech. As a result, she filed a petition for writ of habeas corpus, where she was detained in the District of Massachusetts. The claims were a violation of her First Amendment rights, due process rights, as well as APA claims. Again, we have a Judge Talwani issuing orders requiring first DHS to provide 48 hours notice before transferring Ms. Ozturk out of the District of Massachusetts, and then later a separate injunctive order that she is not to be removed from the United States still remains pending, along with a number of other sort of speech-related immigration cases along these lines. Another very recent case that the ACLU filed relates to book bans, again, downstream of a couple of executive orders from the Trump administration on and civilian schools run by the Department of Defense. So the Department of Defense Education, the DODEA, the Education Administration, runs civilian schools for basically the children of U.S. military, both in the United States and abroad, has control over the curriculum of those schools. And pursuant to EOs 14-168, 185, and 190, which are, each contain many, many elements, but together amount to a ban on so-called gender ideology, i.e. the notion that transgender people exist, and the limitations on the teaching of so-called divisive concepts in schools, as well as other viewpoints. The DODEA followed those executive orders, or interpreted those executive orders, to require it to remove from school libraries run by the DODEA a number of titles, including extremely famous titles, Mouse, for example, titles that I think most folks consider relatively uncontroversial, and to begin the process of scrubbing its library as well as its school curriculums of so-called divisive concepts using, essentially keyword searches that relate to issues of race and gender. I think the fear here is that this is sort of a precursor to a more nationwide effort to remove supposedly divisive concepts from library books and curriculum in public schools. This case was brought on behalf of a group of students attending these schools at various grade levels, all the way from K through 12, and it's a straightforward First Amendment claim, in particular that any efforts to remove library books based on the viewpoints that they represent, or curriculum materials based on their viewpoint, is a direct First Amendment violation under the famous Board of Education versus the PICO case, and as well as Island Trees, which together stand for the proposition that government officials are prohibited by the First Amendment from prescribing what shall be orthodox in issues of politics or religion. And this is a relatively straightforward attempt to do just that. Brand new case, still pending, waiting for responsive pleading and seeking injunctive relief here as well. There have been many other challenges, both direct and indirect, involving the ACLU and otherwise. Recent challenges to the cancellation of student visas under the Student Exchange Visitor Program without due process. You may have seen news of the rash of more or less unexplained student visa cancellations for no apparent reason other than to ship out, I guess, as many highly trained and productive international students as possible in a short period of time, as well as challenges to the executive order requiring the Election Assistance Commission to require documentary proof of citizenship in order for folks to be eligible to register to vote, which unlawfully usurps power conferred on Congress and the states and would violate federal statutes, including the Voting Rights Act, if implemented. That's the League of Women Voters Education versus Trump, filed just a couple of weeks ago. So, 120 EOs, nearly that many pieces of litigation filed by a number of different litigants. But I think the thing to remember is that, number one, these EOs are being issued at an alarming clip day to day, so there will certainly be more to come. And there are extremely broad swaths of existing executive orders that have been challenged, that remain in place, that have not been challenged yet, that could have, tremendous impact, as well as, executive orders that haven't been challenged at all, that could, transform entire aspects of our life. I mean, the executive order that the president issued relating to the teaching of divisive concepts in public schools is sweeping in its breadth. It could upend public education as we know it. Litigants have not gotten around to challenging that one yet, but it potentially could spawn as much executive order litigation as has existed in a generation before the Trump administration. So this, to call this a sort of a hot topic is a gross understatement. I mean, I think that we've seen a transformation of the notions of executive power that are playing out before our eyes. And so, stay tuned for what will undoubtedly be, a brisk evolution of the law as it relates to executive orders over the coming weeks and months.
All right, Professor Franklin and Mr. Fee, thank you very much for your informative and educational remarks. I should let the participants know that if you've registered for this CLE, that the bar will email to you the materials that were presented during the CLE by the professor and Mr. Fee. We've gone over time, so I think this would be a good time to conclude and close the CLE. Thank you for all who participated. And thank you to Joe Holmesy and Tony Ezzi for their invaluable assistance in helping me organize the CLE. And again, Professor and Mr. Fee, thank you very much.
Thank you.
Thank you, everyone. That concludes today's CLE. We appreciate your attendance, and thank you to our speakers and to Judge Bitar for coordinating this. Take care, everybody.